Vicarious liability. What is vicarious liability? It occurs when one person is held responsible for the negligence of others. I mean, there are three parties, one claimant, one defendant, and one third party. And third party did something wrong, and now defendant is liable for his wrongdoing. That is vicarious liability, where one person is held responsible for the negligence of other. Like employer will become responsible for the negligence of his employees. Typically, this applies in employment contract, where the employer is responsible for negligent act of employee, which occurs within the context of employment. And there is a case, Lister and others versus Hasley Hall Limited. A school board employed a warden to manage a boarding house for vulnerable children. Vulnerable children mean underage children. They are not mature. The warden committed sexual abuse of the children, and the claimant, the abused children, sued the school board for vicarious liability. The act of warden, who is liable for that? School manager. They should monitor the work of a warden. They should take care how warden is behaving with the students. So the court overruled earlier decision to hold that the school was vicariously liable. These acts had been committed on the premises and during the time when the warden should have been complying with his duty to care for the children. So the connection of time and place and the inextricable link between the act of abuse and the employment were sufficiently close to establish liability. The court decided, yes, school management is responsible for the act of warden, vicarious liability. Remedies of negligence. Mean what could be the solution against negligence of defendant? Principal remedy is damages, and the damages caused by the claimant must be of type that is reasonably foreseeable. Mean against tort of negligence, what could be the remedy? Mean solution. What claimant will get? He will get the damages. It is the job of claimant to prove that defendant was in breach of duty of care. Only those damages will be awarded that are not too remote. Mean that loss suffered due to breach of duty. Only those damages will be awarded that are not too remote. Mean direct. Indirect mean remote will not be awarded. What are not too remote damages? That arises from direct consequences of the negligence and that were reasonably foreseeable, i.e. contemplation, mean could have been occurred. And there is a case, Hughes versus Lord Advocates. The defendant telephone engineers left an inspection hole covered only by a tent and surrounded by paraffin lamps. The engineers were working somewhere, they put a hole, and at night they put a tent outside the hole and they put a light lamp, so that it can be visible. Child claimant was badly injured when he fell down the hole carrying a lamp which exploded on impact, causing a fireball. The child was attracted to the lamp and he was going to touch the lamp and he fell into the hole and the lamp fell down over him. And there was incident of fire as well. The defendant were liable as they should reasonably have foreseen that a child would be attracted by the lamp and might be burned when playing with them. It was irrelevant that they could not have foreseen the explosion or the severity of the burn damage. Mean foreseen damages. What could be foreseen damages? These kind of damages could be foreseen. Defense to claim in negligence mean what could be the defense? There are four main defense to charge of negligence. Contributory negligence. Contributory mean not full. Some part of loss will be suffered by the defendant and some by the claimant himself. Voluntary non-fit injury. Voluntary non-fit injury. What does that mean? We're gonna discuss later on. Like if we are going for mobile repair, the repairing shop person sign a contract. Like if your mobile got dead, we will not be responsible. That signed contract of loss is called voluntary non-fit injury. That is also signed in boxing match as well. If you got dead during boxing match, the other person will not be liable. If he hit somewhere and you got dead, he will not be liable. Nervous actus intervenus. In simple word, intervention. One person while driving hit other car. He hit on the side mirror also. Due to his negligence, what is loss of other car? Only the side mirror. Is that? The person who was driving other car, he got fumbled while driving and he hit his car by wall on the roadside. He damaged the other mirror. So he can claim for both side mirror or one side mirror. Maybe both, maybe one. Because due to his wrong act, only one side mirror got damaged. Yeah. The other parts might be damaged by due to his own mistake. He couldn't control that. Section, right? The question section. If it is directly linked with that, then he can claim for both. But while parking the car on the roadside, he hit other side mirror with the wall, then this is not directly linked with the act. This is due to his issue. Exclusion clause mean what kind of damages can be claimed? Contributory negligence. So defense in negligence, defendant will have to prove that he was not negligible. This will happen if harm would not have normally happened if proper care was taken. Mean defendant can save himself if he can prove I not liable for that. I was following proper standard of care. So defendant will have to prove that he was not negligible, and this will happen if harm would have not normally happened, if proper care was taken. Recipsa liquator. Recipsa liquator. Mere occurrence of some type of accident is sufficient to employ negligence. What does that mean? We're going to discuss through our case. Let's move towards a case. Jones versus Levox curious. The claimant was riding down a slope leading to the bottom of a quarry on the back of the defendant's vehicle. This person was climbing behind the vehicle of this. He warned him there could be chance of accident. Mean the vehicle coming from the back could hit him. He warned him. Contrary to their orders, mean he warned, but he didn't listen to him. When another vehicle of the defendant was negligently driven into the back of the first vehicle, as a result, the claimant was injured. The claimant exposed himself not only to the risk of falling off the vehicle, but also to the risk of being injured in the particular way in which he was injured. The court therefore found that he was contributory negligent. Because though the driver was on fire, if somebody is climbing behind your car, you should not allow him. But as he warned him, so he didn't follow his instruction. So both were liable. This is called contributory negligent. Mean claimant was not entitled to full damages, he was entitled to part damages. There is another case, Jones versus Levox. Yeah. Sires versus Harlow Urban District Council. The claimant, having paid to use a public toilet, found herself strapped inside a cubicle which had no door handle. So the lady, Sires, went into the public paid toilet and she stuck into the toilet. The cubicle toilet mean having no roof. It's just a box of wood. And there was no door handle so that she can came out. So what she did, she attempted to climb out by stepping first on the toilet seat and then on the toilet roll holder. Toilet roll holder is not that enough that it can hold your weight. So which gave way and as a result, she was injured. The court decided, yes, the company who is managing those toilets, they are liable. But she did mistake by herself as well. If you try to put your whole weight on the roll holder, so that is not that much sufficient that they can hold your whole weight. So you are also liable. So contributory negligence. So the injuries she suffered were a natural and probable consequences of the defender's negligence, but that the damages would be reduced by 25% since the claimant had been careless in defending for sport on the toilet roll holder. Let's move back. So defenses in negligence. Defendant will have to prove that he was not negligent. This will happen if harm would not have normally happened if proper care was taken. And recepsa liquidator, mere occurrence of some type of accident is sufficient to employ negligence. Mean the things that look like defendant was in control of situation and victim wasn't. Mean he has to prove these things. And there are four main defenses to charge for negligence: contributory negligence, voluntary non-fit injury, nervous actors intravenous, exclusion clause. What is contributory negligence? That we have covered. If a victim himself was responsible for his own injury, case of toilet case, then defendant can plead for contributory negligence. Court may then reduce the damages depending upon scenario. It is only partial defense. What is a voluntary non-fit injury? If a victim himself was given consent, like in a boxing match, both the boxer give their consent. In case of death, other person will not be liable. In case of mobile repairing, we give consent if during repairing mobile motherboard got dead, the shopkeeper will not be liable. So if victim himself has given consent for loss, then it exempt defendants to show duty of care. Consent can be expressed agreement or implied from claimant's conduct. If you are going for boxing match, it is implied consent. But in the case of mobile repairing, they take consent on written agreement. ICI versus Shatner relating to consent. The claimant and his brother were certified and experienced shot firers employed by ICC Limited in a quarry owned by the defendant company. Part of the brothers' work included writing up detonators, wiring up detonators, and checking the electrical circuits. They ignored defendants' rule relating to safety and tested the detonators without using the shelter provided. And they were certified and experienced shot fire, mean some kind of electrician. One of the brother was injured and claimed his brother was 50% to blame for the explosion and that the employer was vicariously liable. Though we didn't follow the rules, but half damages should be paid by the employer, mean company as well. And the court decided no, there is no contributory liability. Why? Because you are the certified and experienced shot firers. You should know about the rules. So both brothers had impliedly consented to the risk of their action and therefore the defendant was not liable. Consent acts as a complete defense and no damage would be awarded if it is shown to apply. Nervous actus in intravenous, what does that mean? If defendant did something wrong, claimant suffered some loss. There was a court case going on for the amount of loss. Suppose the loss amount is $100. Before that court case decided, there is any other event that cause more loss to the claimant of say $50. This is other event is an intervening event that happened after the defendant wrongdoing. So claimant will be liable for this only rather than complete 150. This is called nervous actus intravenous, mean intervention of any other or event. Where there is a new intervening act, this may break the chain of causation, removing liability from the defendant. There are three types of intervening act that will break the chain of causation. Nervous actus intravenous. When there is a new intervening act, it breaks the chain of causation, removing liability from defendant. These are unforeseen events that breaks link between defendant, tort, and eventual harm. And there are three types of intervening act of claimant. If due to act of claimant, loss is increased, then defendant is not responsible for that increased loss. Mean he hit the one side mirror, but while parking car on the roadside, he damaged his other side mirror due to his fault. So that parking on the roadside is an intervening event. And there is a court case. McHugh versus Holland. The claimant sustained an injury at work due to his employer's breach of duty of care. He strained his back and hips, and his leg was prone to giving way. Mean due to employer safety rules, lack of safety rules, employee got injured his back strain and hip. And due to that, he was unable to stand on his leg properly. This means he should take care while working. While in this state, he attempted to climb unaided down a steep concrete staircase without a handrail unaided. And he tried to climb through a staircase. And he got part way down and felt his leg give away. So he jumped 10 steps to the bottom. He suffered a fractured right ankle and was also left with a permanent disability. The employer is liable for what? For this. He cannot claim damages for complete injury because the second injury caused because of intervening event. So the defendant accepted liability for the injury sustained during his employment, but disputed liability for the second injury resulting from the claimant action in jumping down the stairs. So court decided that claimant action amounted to nervous actus interventions because his action is attempting to climb the steps unaided, knowing that his leg might give away, was unreasonable. The defendant was therefore not liable for the injuries resulting from the incident on the stairs. Nervous actus intervention means the intervening act could be act of claimant, could be act of third party. If due to act of third party, the loss is increased, defendant is not responsible for that increased loss. You hit on the side mirror only. And after 3-4 steps, the car hit by any other car, the third party. Now the first person, the first wrongdoer is not liable for the complete loss. There is a case. Lamb versus Camden LBC. The defendant, Camden, counsel negligently struck a water pipe outside the claimant's house. This caused extensive damage and the property had to be vacated. I mean, there was leakage of water in the complete house, so they vacated the property, they shifted somewhere else. I mean, who need to make repair of the house? Obviously, the council. They were the tenants over there. 1 year later, we see that property became vacated for 1 year. 1 year later, the council had not undertaken the repairs. Squatters, looters, gangsters had also moved in because the house was empty. So they also moved in and caused further damage. The claimant arranged for repairs to be done herself and submitted a bill to the council for the repairs and damage caused by the squatters as well. No, that squatter damage is done by third party, and that is intervening event. Council is responsible for the water damage only, not for the squatters damage. So the local authority was not liable for the act of squatters. It was not foreseeable that squatters would move into the empty house. Natural events, an intervening natural event will normally break the chain of causation unless it can be shown that the defendant's breach has either increased the likelihood of further damage from a natural event or has made the claimant more susceptible to damage. Mean if any loss occurred due to natural damage after the action of a defendant, so that natural damage will not be claimed from the defendant. So the intervening event could be act of the claimant, act of the third party, or natural event. If due to natural disaster, the loss is increased, then defendant is not responsible for that increased loss. And there is a case. Karsloggy Steamship Company Limited versus Royal Norway Corp. So this is a ship company who rented out their ship, and they are the customer. They took the ship from the ship company. That ship got damaged. So they asked for the repair. They said, okay, whatever will be the cost of the repair, we will pay. So they sent the ship for repair. During the way, due to storm, the ship got some other damages. And now they are claiming for the whole damage that caused due to storm as well. No, due to storm, that damage is natural cause. So they will be liable for the first damage, not the complete. So the claimant ship was damaged in a collision as a result of the defendant's negligence. The ship was en route, mean moving, to have the resulting repairs carried out. On the way, the ship was damaged further by heavy weather and as a consequence took a longer period of time to repair. The claimant claimed compensation for the loss of profit for the period the ship was unusable due to the original incident. No, they will be liable for the damage rather than the delay due to natural causes. The claimant could not recover compensation for the time it would have taken to repair the ship in respect of the collision damage, as the ship would have been out of use if any case due to damage caused by the weather. An exclusion clause is one which seeks to exclude or limit liability for negligence. If you are signing a contract with other party, and in a contract you have included exclusion clause, like in case of any damage, I will not be liable. In that case, defendant is not liable for it. If there is exclusion clause, exclusion from liability. An exclusion clause may fall within the provision of the Consumer Right Act. So if any exclusion clause is found to be valid, this constitutes a viable defense against any action for negligence. Act of God, in addition, liability is excluded if it is possible to say that the act occurred in the course of nature, i.e., that it was an act of God, something beyond human foresight, which the defendant would not have been expected to provide against me due to natural causes. The last concept, the thought of passing off. The thought of passing off. If there is already any business with a name of ABC and you have started your business with the same name and the existing business lost something due to customer sale, so they can claim for damages. This is called tort of passing off, means civil negligence of using some other business name. Tort of passing off means civil negligence of using some other existing business name. If they lost something, they can claim for damages. So this tort protect the goodwill, mean business name, business repute, reputation, and profit of a business. The tort of passing off arises where one business uses a name which is similar to that of an existing business. Number two, it misleads a person into believing that they are the same business. I mean, you are misguiding the customer like this is the same business, is of their branch. And it causes actual damage to that business or will probably do so. In that case, you will be liable to pay damages of the already existing business loss. If passing off is proved, then you use the name of other business that is already existing in the market. And this mislead the customer as well as they suffer loss. The court may restrain the business from trading under that name and order that damages to be paid to the person whose business has suffered loss. And there is a case, Ewing versus Buttercup Margarine Company Limited. Buttercup Margarine Company Limited is a new business that they created. Ewing was having a business, Buttercup Dairy Company. So they started a Buttercup Margarine Company Limited as both are relating to dairy products. Similar business name, similar business nature. So they could mislead the customer. So Ewing, who traded under the name Buttercup Dairy Company, sued to restrain a newly registered company called Buttercup Margarine Company Limited from using the name on the ground that the general public might reasonably believe that there was a link between the two businesses. So the court held that the word buttercup was so closely associated with Ewing dairy products as to be likely to cause confusion if used by the similar marginal business. An injunction was granted to prevent the defendant company from trading under its name. Injunction means stop doing something. So if passing off is proved, the court may restrain the business from trading under that name and order that damages be paid to the person whose business has suffered loss. But if a company feels that another company has a name which is too similar to its own, it may object the company name adjudicator under Company Act 2006, whose adjudicator is a legal person. We will read about him in the later chapter of company law. The adjudicator will consider the case and then make their decision. In most cases, the adjudicator will require a name change. He will ask you to change your name. And in some cases, the adjudicator may state the new company name. He will impose the new name. The last page of this chapter. Professional advice and negligent misstatement. If being a professional, you are giving any advice, you are making any statement, and based on that advice or statement, the other party suffered loss, you will be liable. So a party can suffer loss by relying, mean believing on incorrect advice or false misleading statement. In order for an action of negligent misstatement to be successful, there must be special relationship between both parties. Special relationship. What is special relationship? It exists where a professional person advise a known person, mean his client, who relies on statement for known purpose. If unprofessional person giving any statement, other person is not his client, but they are taking action based on his statement. So in that case, defendant will not be liable. There should be a special relationship. If one person suffering loss based on the device or statement of other party, so they can claim for damages if there is a special relationship. What is special relationship? A professional person giving advice to a party who is relying, mean that special person know, that professional person knows they are behaving against my advice because they are my client. Liability will only arise where defendant is in a business of giving professional advice and statement is given in that context. If any person has put any of the statement and other laymen are relying on that statement and taking action, they suffer loss, they cannot claim for damages because there is no professional relationship, special relationship. Auditor of duty of care to company only, i.e. shareholder. Who are auditor? Who give opinion on company financial statement, whether financial statements are true or wrong. Who appoint the auditor? Shareholder. So auditor is liable to shareholder only. If he said financial statements give true and fair view, afterward financial statements proved wrong, so he will be liable for losses of shareholder only. If shareholder made more investment based on his audit opinion, he will not be liable for other parties. He will not be liable for general public. If general public made investment decision based on audit report, auditor will not be liable for that. Auditor don't owe duty of care to the general public and shareholders that are planning to increase their shareholding, mean prospective investors. Prospective mean who want to become a future shareholder of the company. He is liable for shareholder and company only, not for the general public, not for the prospective, mean future shareholders. Accountant who is working as a accountant preparing financial statements for a company, or duty of care to the clients, mean for the company for to whom he is providing accounting services, and to all those whom he know will rely on accounts, including general public, including prospective investors. Pure economic loss with respect to negligent misstatement is recoverable. If accountant have stated any misstatement negligently wrong, the loss directly, even indirectly, will also be recoverable. Pure economic mean indirect to remote. If action is, if auditor is auditing accounts of subsidiary company, then he owes the duty of care to both parent company and subsidiary company. He cannot say I'm liable for only management and shareholder of subsidiary company. No, you will be liable for the management and shareholder of parent company as well. Because subsidiary result will be incorporated into parent company financial statement. So auditor is liable for company and shareholder. He is not liable for general public and prospective investors. Accountant is liable for his client as well as all the parties who are using accounts for their decision making. Pure economic loss in case of negligent misstatement is recoverable. And auditor, if auditing subsidiary company financial statement, he is liable for parent company as well as subsidiary both. To finish, let's cover some MCQs. 7.1. Good luck, everybody. Which of the following statement concerning tort is correct? Breach of contract is a tort. Tort are crimes? No, it's civil wrong. A tort is a civil wrong and the victim sues for compensation or an injunction. See, because breach of contract is a tort, no. Contract is not necessary in case of tort. Yeah. See, 7.2, which of the following describe the tort of passing off using name, similar name? The use of business name or trademark that mislead the consumer to believe that one business is that of another. Yes. What is B? Misleading a consumer to take action that are to their detriment. A consumer deliberately wearing a product that purports to be made by one brand but which is actually a fake. Mainly is option A. Number 3. In which of the following circumstances will a defendant be liable to pay compensation under the tort of negligence? They breached a duty of care to the claimant. They breached a duty of care to the claimant, and as a consequence, the claimant suffered loss, injury, or damage. Obviously, there should be loss suffered due to that breach of duty, not only just a breach. Their action caused the claimant to suffer some loss, injury, or damage. B option. 7.4. In the tort of negligence, what is the legal effect of res ipsa liquidator? The claimant must prove that the defendant was negligent. The defendant must prove that they were not negligent. Obviously, defendant have to prove. The claimant must prove no, only defendant has to. 7.5. In which of the following circumstances would an employer be vicariously liable for the act of employee? Where a loss or damage was caused by the employee when performing the duties they were employed to do so. Where the loss or damage was caused by employees, but they were not on company business at the time of an incident. If they were not on company business, there is no employee. Where the employee was a valid defense to liability and the injured party has no other course of action available to them, no. A. 7.6. In the tort of negligence, what is the effect of a voluntary non-fit injury concept? The defendant is liable for the claimant injury unless proved otherwise? No. The claimant accepted the risk of injury and the defendant is not liable for the claimant's losses. Yes. Given consent. Neither the claimant nor the defendant is responsible for the claimant injury. No. Obviously, if there is a written consent, then claimant cannot claim for damages. He will suffer the loss. I mean, part 3 is showing nobody is responsible. No, claimant will be responsible for the loss. 7.7. Which of the following statement describe whom a company auditor owes a duty of care to? The public, At large, no. The company shareholder who read the company accounts and increase their stake in the business, the company only. The company's shareholder who read the company accounts and increase their stake in the business mean this is related to prospective investor. The company's shareholder who read the company accounts and increase their stake in the business mean invested after the audit report mean prospective investor. So he is liable for company, company and its shareholder only. 7.8. Which of the following statement regarding tort is correct? The only remedy for a victim of tort is damages. No contractual relationship need exist between claimant and defendant for the defendant to be liable to be claimant in tort. Contractual relationship is not necessary. Action in tort are heard in the criminal court system. No, civil, because it's a civil wrong. In tort, the burden of proof is always on the defendant to prove that they were not negligent. No, burden is proved mainly on the claimant. He has to prove duty of care, breach, and loss suffered due to breach. 7.9. To establish a case of passing off, what must the claimant prove? The consumer purchased fake goods. No. The defendant is using similar business model to the claimant. This is not business model, business name. The name of defendant business is similar enough to the claimant's mislead the consumer. Yes, due to that, consumers are also misled. There is some similarity between the name of the defendant business and that of the claimant. Not only similarity, consumer must be misled. Yeah. C. Complete. 7.10. Which two of the following are questions that are asked to establish whether the defendant or the claimant are duty of care? Was the harm obvious to a reasonable person? Was there a relationship of proximity between the parties? Did the claimant accept the risk of injury? It is a fair, just, and reasonable to impose a duty of care on the defendant. Mean court can reasonably impose a duty. So B and 7.11. When considering whether a defendant has breached their duty of care, a number of factors are considered. Which of the following statement concerning breach of duty of care is correct? Where there is a high probability of injury, the claimant should have taken extra care. There was no probability, there was a risk. A social benefit to a defendant action is no excuse for breaching the level of care expected. Defendants are not expected to ensure that all possible precautions against risk are taken if the cost of the precautions outweigh the risk. He need to decide based on cost benefit analysis. A professional is expected to demonstrate the same level of care and skill as a reasonable person performing the same task. No, he should show more care. So I think C is good. 7.12. Which of the following circumstances will prevent casualty being established in a claim of negligence? Prevent casualty being established in a case of negligence. 5, please. An act of the claimant that is reasonable and within the normal course of things. Act of third party that occurs after the claimant's injury. Foreseeable natural events. Multiple possible reasons for the injury with no one act being established as a cause. I mean, this is about intervening event, so they could be multiple. by the claimant himself, by the third party, by any of the natural cause. 7.13. In the regard of professional negligence, which of the following statements are true or false? Accountant auditor. Pure financial loss caused by negligent misstatements are not recoverable. No, they are recoverable. It's false. Auditor do not owe a duty of care to members of the public who rely on public accounts for investment decision. Yes, he is liable for the company and its shareholder. 7.14. In which of the following circumstances will an accountant owe a duty of care? Where they prepare a statement for general public circulation, where it is unknown who may rely on the information and for what purpose duty of care was opt or no duty of care was opt. No duty of care was opt because they are unaware. Where they produce information for a particular person in the knowledge that the person will rely on the information when making a decision about a transaction, yes, duty of care was opt. 7.15. Which two of the following parties does an auditor owe a duty of care to when auditing the accounts of a subsidiary company? To parent company and to subsidiary company. Here is one MTQ. We need to cover 8.5. Roger regularly takes part in a sport that involves fighting with the wooden sticks. He has been successful in many fights, but recently took part in one in which he lost to Jack. The fight took place under the necessary safety regulation and was stopped before Roger was hurt too badly. However, soon after the fight, it was clear that he had received severe head injuries and he now has difficulty talking. This is the case of Roger. Lulu used a public toilet at her local train station. Unfortunately, the lock was defective and she was stuck inside. In a hurry to escape, she attempted to climb out of the window despite a wearing notice not to do so and fell to the ground outside, injuring her head. Contributory negligence. Similar case. Okay, part A. Which two of the following must a claimant prove to be owed a duty of care in a negligent claim? The harm was an obvious consequence of the defendant's action. Yes, you need to prove. There was a relationship of proximity between the parties. It is fair, just, and reasonable to impose a duty of care. The defendant has suffered funds to pay damages for the harm caused. Which two of the following must a claimant prove to be owed a duty of care in a negligent claim? The harm was an obvious consequence of the defendant's action. I suffered loss due to defendant breach. There was a relationship of proximity between the parties that claimant do not have to prove. It is fair, just, and reasonable to impose a duty of care. The defendant has sufficient funds to pay damages for the harm caused. No, this claimant cannot. So, 1 and 3. Part B. Which of the following statement about Roger is correct? Roger cannot claim damages from the fight organizer because the organizer can claim the defense of a voluntary non-fit injurer. Because if you are fighting, there could be chances of injury. And this is the concept Voluntary non-fit injury. Roger can claim damages from the fight organizer because the defense of voluntary non-fit injury does not apply to dangerous sports. No, it applies even to dangerous sports. Roger can claim damages from the fight organizer because he did not expressly consent to the risk of head injury. No, there is implied consent. Roger cannot claim damages from the fight organizer because the injuries suffered were in reasonable contemplation. No, this is the concept of voluntary non-fit injury. Which of the following statement about Lulu is correct? Lulu has no right to damage in respect of her head injury. No, if the lock is not working, she can claim for contributory negligence. This is wrong. Lulu has no right to claim. No, she has a right. Lulu has a right to claim damages for the full amount of the harm caused to her in respect of her head injury. No. Lulu has a right to claim damages in respect of her head injury, but the amount she is entitled to will be reduced because she was partially to blame for it. So that's it for today.